601, I'm sorry, 125-104, State v. Anderson.
May it please the court, Peter Meharry for Todge Anderson. If I could reserve 3 minutes of my time for rebuttal, Your Honor.
3 minutes is reserved. Thank you, Mr. Mayor.
Thank you. In this case, my client was convicted of felony murder along with alternative charge of murder 2 and some secondary charges that arose from a killing here in Topeka. The defense at trial was that my client was misidentified, and the 2 main witnesses against my client were bought and paid for by plea deals that the state gave them. Shortly before trial, the Friday before trial started on Monday, the state produced to the defense a recording of my client during a jail call he had with a visitor at jail here in Shawnee. State had not produced it prior to that time. Defense counsel did not know that the state had it and certainly did not know that the state intended to use it. The state found that it was a key piece of evidence because they believed it was what amounted to be a confession to the drug distribution charge, as well as statements from my client that corroborated their theory of the case. And that was that this was a killing because my client was unhappy with the amount of money he was getting in the drug trade. He was unhappy with his share. Defense counsel asked that the district court suppress that and rule that that is inadmissible because of the late disclosure. The court overruled that and allowed that into evidence against my client at trial. We've argued.
Help me understand how that, what the basis of the discovery violation is here. Because I know that the parties had a discovery agreement, and I don't believe that agreement's in the record. So are you suggesting the basis of the violation is statutory?
Your Honor, we are alleging that it did violate the discovery statute and was not timely disclosed. There was a discovery agreement. Everybody agreed with that. There was no dispute about that. And there certainly was no dispute that this was not produced in line with that. Further, I would point out to the court at the pre-trial, which was in January, mid-January, about another 3 weeks before trial, the state indicated to the court as well as defense counsel that they had produced everything, that there was not going to be anything else in discovery.
So the statute allows, it could be disclosure, it could also be inspection. And what I guess I don't understand is, were the calls in general available to the defense to inspect at any point during trial, or was the discovery agreement, did that limit the discovery process to just disclosure?
As far as the calls being provided by the state, just generally speaking, open file policy, stuff like that, the state did not have this, at least the prosecutor did not have this until the week before. The testimony of Detective Regan, I believe I'm pronouncing that right, was that initially when my client was arrested, he did listen to some of his calls, but then that kind of tapered off. But the week before trial, he went back and started listening to him again, and that's when he discovered this call. So the state, the prosecution did not have it because they didn't look. Detective testified, I didn't really go look until the week before trial. So it was only then that it became available to the defense.
Well, it seems then that the foundation of your issue here is that you're imputing what the law enforcement officer knew, or the detective, or I don't remember who it is, to the prosecutor, right? Because the prosecutor, when you look at the plain language of the statute, the prosecution or the prosecutor, they didn't know about it, right? They didn't know about it until the Friday before.
That is what the prosecutor stated, but I would say not necessarily imputing, but the statute says the prosecutor has to disclose things that it knows about and with due diligence would know about. And we've all had cases where jail calls are used against defendants. I've had my fair share. It's usually a nice little treasure trove for the state as far as evidence against defendants.
So it's your position in every case, the prosecutor should review all phone calls, even if the defendant's been in jail for 3 years, that all phone calls, that it's it is due diligence that a prosecutor review all phone calls of a defendant?
If they want to use that to convict my client and send him to die in prison, I think they should. And I think they should provide it to the defense.
That's reasonable.
Yes, it is. They are using this to put my client away. If they want to use it, they need to go look for it, and they need to disclose it in a timely manner so that my client can review it, analyze it, so as defense counsel can review it and analyze it and properly advise my client.
Did defense counsel ask for a continuance to be able to, because it seems like the only prejudice here was that there was no ability to cross-examine the person on the other end of the phone call?
I think, well, number one, he did not ask for continuance, but I don't believe he has to ask for continuance in this situation. He can certainly ask for the court to suppress the evidence. That's one of the options within the statute. So just because he did not ask for continuance doesn't mean he's somehow waiving this issue. And don't forget, my client was sitting in jail waiting for his day in court. And he should not have to continue to sit in jail because state didn't bother to go look and see if there's any jail calls they wanted to use. So just because he did not ask for continuance doesn't mean that what he did waives the issue as far as asking for the court to suppress.
Is there any harm alleged other than surprise?
The harm alleged by defense counsel was certainly that they did not know that they were going to face this at trial. They could not investigate it. So they were caught off guard. And certainly this was disclosed Friday before the Monday trial. Up until that time, the defense was preparing for trial, not knowing this was going to be part of it. They were preparing with the, as far as their defense based upon what had been disclosed. So I think the surprise that the state was going to use this changed or hampered how defense prepared itself.
Is there any surprise with regard to the recipient of the call? Person who was on the other side of the call?
I believe defense counsel said he did not know who exactly that was, if I remember the record correctly. It was identified as my client's brother at some point. But I believe defense counsel said he could not go out and locate that individual because of the short time period.
Is there any case law to support your position about the due diligence having to review all, having to review all these phone calls?
As far as specifics saying the state has to go back and look at everything, I don't think I have a case and I can point this court to. But I would reiterate, the statute certainly talks about due diligence. And the whole point of discovery statute is for the state to say, hey, we're charging you with X, and this is the evidence we have to prove it. That way the defense can evaluate it, they can investigate it, they can determine how they want to fight it at trial. And that certainly was not the case here because of this late disclosure.
Just one final question, and we're reviewing this for abuse of discretion, correct?
You are reviewing it for abuse of discretion, but I think there's two components to that we've raised in this case. Number one is just standard abuse of discretion. No reasonable person would allow this. But secondarily, we've also said that the district court made an error of law because the district court found that this was already discoverable. And I don't think that comports with the statute. The district court seemed to rule that because the defendant made these statements, it's already discoverable and there's no obligation by the state to produce it. The statute 2232.12 clearly talks about the state's obligation to produce defendant's statements, confessions, etc. So I think that's a misreading of the statute by the district.
Is there any other, following up on Justice Standard's inquiry about continuance, but is there any other cure if we find that there is a discovery violation to this other than suppression? I mean, you're just arguing suppression. That's pretty much the only option the court should have exercised.
Your Honor, I think the court could have continued it. I think the court could have suppressed it. The statute talks about different ways to try cure these problems. Defense counsel asked for the evidence to be suppressed. So that's what we're working on. But I think the court could have said, we're going to continue the case for a week to give you time to look into it. That is one option the court has, but certainly that's not what the court did and certainly not what defense counsel asked here.
I'd like to drill down a little bit into your error of law claim and try to figure out how the statute should work.
Sure.
And we are talking about 3212 subsection A. correct? That's the subsection that you're working from that describes the exercise of due diligence and so on.
Yes,
That provision begins upon request. Prosecuting attorney shall permit defense to inspect, copy, or photograph. Was there a request made in this case?
my understanding, and this was stated in the record, was that there was a standing discovery order. It's not. I
Well,
can't
but that's
find,
different from the statute, right? An order might say something that's
sure.
more demanding than the statute, but your
So-
claim is under the statute.
My claim is under statute, and my understanding, the way it was talked about below, what there was just a standard discovery order out there that the state produced
Okay,
pursuant to the statute.
so that goes directly to my next question, which is, in your argument, you've described the duty as a duty of production, must produce. I don't see that in the statute. Where are we getting that from the statute? The must produce language.
Your Honor, if they have it, the statute says the attorney shall permit them to review. And I,
Fact, copy, or photograph.
correct, and that's, I think, a mandatory obligation on the state to allow the defendant to see it. And
On
in-
request.
on request, but if there's a standing request and the state comes up with something,
What was the standing request?
and I don't know because that's not in the record.
Doesn't
They
that
just,
hamstring us pretty badly here?
I don't think so because there's really no dispute that there was a standing discovery order in this case. There's no dispute that this had to be produced under that. The state never said this was different. They just said we didn't have it until the week before trial.
Well, they said they didn't know about it.
Right.
Is there anything in the record that suggests that the defense team was prevented from looking at the reviewing the jailhouse calls?
Your Honor, I don't know what Shawnee County Jail's operations are as far as letting defense counsel look at them. So there's nothing indicating in the record as to whether or not defense counsel could have done that or not. But I think
Doesn't the statute put the onus on the defense to inspect, copy, or photograph?
the evidence the state intends on using. I mean, certainly the defense has an obligation to investigate. But I think the whole point of discovery is for the state to say, this is the stuff we have on your guy. And the defense then has the ability to look at it, investigate it, and determine how to proceed. Otherwise, we're back to trial by ambush. State produces everything the day before trial. Here you go. And I don't think anybody thinks that that gives a defendant a fair trial.
Does the record tell us, I really just can't remember, or if I even saw this, but just let me ask. Does the record tell us whether the detective who came across this recording, had a pile of recordings and then, looked at them periodically, but had them in his possession or her possession? And was just getting around to it, as opposed to went and asked the jail and got it and then suddenly discovered it?
I don't know that the record
See
is,
what I'm asking?
I don't
wonder
know-
whether they were sitting on it.
yeah,
for-
I don't know the record is clear as far as if he had possession, like on a thumb drive or something like that. But his testimony was certainly that when my client was first arrested, he did listen to some jail calls, but then that essentially tapered off over the course of time. And here my client was arrested in May of 2021. The detective said, when that took place, I did look at and listen to some jail calls, and then it tapered off. But then the week before trial, he said he went back. So I don't know if he just goes to, it wasn't said on the record, if he just goes to Shawnee County Jail and says, I need these, or if he has them on his desk. That, like I said, I don't think that's clear in the record.
I'm kind of fishing around the idea that if the state had possession of the tapes, then there was really nothing stopping the defense from asking to inspect everything that's in the state's file, which I'm, you're kind of including the police in that, and I am too. So, what stops the defendant from looking at everything that the police are sitting on?
And I don't know if there's a difference between what the detective had and what the prosecutor had. There seems to be a little bit like there's a difference there from the record. But the way I read the record is what the state was producing, the prosecutor was producing to the defense, what he had access to did not include these. So it
No,
was-
there's no allegation that the state sat on this longer than they needed to once they knew about it.
no, that is true. The detective testified, he found it sometime the week before. The state said they got it, I think maybe the Wednesday or Thursday, and they produced it that Friday.
So so they stumble on it and they give it to you pursuant to their agreement because now they've seen it.
They stumbled on it because they didn't look for it.
So you're arguing for a rule of law that requires them to look for a certain period of time if they want to use evidence against you.
If
Towards a discovery cutoff that says nothing else comes in.
Yes, that's absolutely right, because here, they didn't look until the week before trial. The detective testified, he went back the week before trial. And that's when they started looking. And if they want to use that to send my client to prison for life, that's too late, because my client can't do anything about it.
You're clearly entitled to conversations that your client had with anyone in the jail, from the jail.
I don't know that. I mean, as far as what Shawnee County Jail produces to defense, I don't know. In this case, about all I can tell you is that the defendant certainly seemed to have access to those.
Does it matter? I mean, if you subpoenaed all of your telephone conversation recordings from the jail, is there any possible objection you can think of
Not
to
that
the
I can
jail
think,
producing that?
not that I can think of off the top of my head, Your Honor. But, and I'll just make this one final point, probably reiterating what I've already said. The point of discovery is for the defense to know what the state has. That's the point of discovery, so that they can prepare for trial. Because that did not happen in this case. We believe my client did not get a fair trial, and it warrants reversal by this court.
But the defense isn't confined to that for your own discovery, correct?
They aren't confined to it, but they need to know what the state is going to use.
And it's not the state's obligation to tell the defense everything that they're going to submit at trial, is it?
It's not that they're going to say, we're going to use these 4 exhibits, but they do have to tell the defendant, this is the evidence we have that we could use at trial, that we have against your guy, so that the defense can prepare.
Pursuant to your contract or agreement with the state, correct?
Pursuant to both any discovery order that's in a case, as well as the discovery statutes that we have in the state.
So was a discovery order entered in conjunction and pursuant to the agreement you had with the state?
As far as the discovery order in this case, they talked about it, that there was this discovery order out there, but it's not in the record, Your Honor, so I don't know exactly what it says.
Can I ask you a quick question about your prosecutorial error issue?
Sure.
I'll just tell you where I'm reading the closing argument that you challenge here before us. My first blush is the prosecutor's making an argument, and it looks like it could go one of 2 ways. It could either be improper burden shifting of the burden of proof, or it could be a proper argument about defense having a subpoena power as sort of a rebuttal to the defense's closing argument that there's a lack of corroboration in the state's evidence. And then there's a fairly contemporaneous objection launched by defense counsel, and the district court essentially says, you're coming close to a line, move on, and they do. Why am I wrong? Or it almost seems to me like it got cut off before the argument was fully developed.
Your Honor, we don't believe it got cut off soon enough, because we think the implication that the state made was that, look, if they have something against these 2 witnesses that testified against Todge, they need to bring in something to show why they're lying. We think it already shifted the burden, and the objection didn't cut it off quite in time. And further, I would point out the state didn't, or excuse me, the district court did not sustain the objection or did not cure it. So we think that the impression left is that, yeah, the defense does have that burden to bring in evidence to disprove those two witnesses. So that's why we think it does cross the line and was not cured by the objection, because the district court did not sustain it or do anything else. Thank you.
Thank you.
May it please the court. Michael Sarah appearing for the state appellee in this matter. Your Honors, I'd like to address Justice Biles' question initially about the record regarding Detective Riggin and what he testified to regarding the jail call. My review of the record, as I recall, Detective Riggin testified he did initially start reviewing jail calls at the beginning of this case. Fell off.
The call existed that time when he
It
was.
did.
Okay,
It was
so
made.
that's what, I couldn't remember exactly when the phone call was made, but it was made kind of contemporaneous with the arrest.
Yes, Judge,
Okay.
the defendant was arrested in Omaha, Nebraska on his federal warrant, transferred to Shawnee County. The call was made 1 or 2 days after he
Okay,
was booked
thank
into
you.
custody. Detective Riggin then testified other cases became a priority. Review of the jail calls became less of one until trial started to ramp up. The week before, he resumed his duties, found this call, immediately disclosed it to the prosecutor, who immediately disclosed it to the defendant. But that is, from my review of the record, that is the sequence of events that how the jail call came to be. Regarding the discovery.
We don't know when law enforcement asked for those calls, do we?
I
from the
believe
record?
Detective Riggin testified he started asking for them the week before trial. The jail calls are stored electronically at the Shawnee County Jail. They're available upon request by either party, is my understanding.
But he had reviewed some initially,
He
right?
had, apparently not this one.
Okay, so, but do we know whether he requested that specific jail call at the outset, or did it?
That I don't know. He didn't testify to that. He just said he began some review of some of the jail calls when the case was new, or the arrest was recent, and then it fell off due to other case priorities.
Is there anything in the record that would describe how the requesting works? Like very practically speaking, if I wanted to listen to a call, do I get like a password and then I just log in, or is there some sort of physical delivery of a thumb drive?
There is nothing in the record, Your Honor. I can tell you how it happens, but it's not part of the record.
But is there a correctional employee that testified that they generally make them available upon request, but
Not in this case, Your Honor. No, the only person who testified regarding the call was Detective Riggin.
Okay.
Regarding Judge Rios's ruling that the call was, he used the word discoverable, but she stated since it was a statement of the defendant, that essentially the defendant knew about it, therefore making it something he had personal knowledge of. I cited to it in my brief at State v. Bancord. Evidence not disclosed to the defendant before trial is not suppressed or withheld by the state, but the defendant has personal knowledge thereof, or if the facts become available to him during the trial, and he is not prejudiced in defending against these new facts. So in order for this to be reversible, Your Honor, I believe there would have to be showing of some prejudice, and the record does not reflect that in this case.
What's your point of citing to that statute again? Is that because the defendant stated was a part of the phone call? It's not discovered. I mean, I don't understand the ruling actually.
I don't like the term the district court used. I believe which the district court was trying to say is your client knew about it, so this can't be.
It says are fully discoverable.
Yeah.
That didn't make sense. to me.
I think that, like I said, I believe the district court was trying to say your client made this statement. It's not a surprise to him that this statement could be used against him later. That fits with that particular holding in that particular case.
What does the state think that the statute was violated?
I don't believe so, Your Honor. There is an exception. I mean, the discovery obligations, even though the statute says there's a 21-day deadline, they're continuing obligations. The state is not allowed to continue to withhold evidence as it discovers it throughout the pendency of a case. Under KSA 223212I, there is an exception if previously unknown material becomes known to the state or another party that is required to disclose it to the opposition. They are to immediately notify the opposition, notify the court, and disclose as soon as it's practical. So I don't believe the statute was violated because I do believe the state complied with the exception under 3212.
So again, I'm gonna ask some similar questions I asked to defense counsel.
Yes, Ron.
Defense counsel used the word produce, you've used the word disclose. Where does that, I understand that that's ordinary trial practice. I remember doing it myself. But it's not, that doesn't jive to me with the actual language of the statute. So where does that come from? Is that an extra agreement and order that the district court enters?
Some district courts do enter a separate discovery order, Your Honor. In this case, I believe the only thing that was done, and I could be wrong because I haven't reviewed it that recently, but I think the only thing was the general reciprocal discovery agreement that all the attorneys signed with the district attorney's office saying we're requesting access to your file and permission to inspect and
Wasn't that true in this case, as I understand the arguments?
as far
That
as.
that the defense counsel had permission to inspect, copy, and photograph all of the jail calls.
I believe that is the case, Your Honor, yes.
So why are we talking about produce and disclose,
I believe because a lot of the way we talk about discovery and outside of the plain statutory language is disclose and produce, because as a general policy, we produce discovery to the defense. We don't say, hey, here's our file, you come get it. I think that's just a general best practice thing. But you're right, the statute says permit inspection. With
And the
re-
exception that you identified under subsection I, factually, that's exactly what happened here.
I believe so, Your Honor, from my review of the record. As it pertains to the prosecutorial error claim, from my review of opening and closing statements of the defense, a huge portion of the defense was this was a misidentification. This was an incompetent law enforcement investigation. They needed to find somebody. He fit the general description. The defendant's the guy they got to pin it on. The defense pointed out not only the misidentification thing in closing, but also that certain evidence that was available to the state and the state obtained was not produced, and posed the question to the jury, well, why wasn't this? Duong states it's not error for a prosecutor in rebuttal to point out that while the defense is under absolutely no obligation to produce any evidence, they have the ability to do so. And that's exactly what the prosecutor attempted to do here. He was cut off by the district court, but what he stated was not, and what he said was not a misstatement of Kansas law. The state is permitted to do that when the defense attacks a case based on misidentification or accuses the state of having evidence they didn't produce with the insinuation that they're hiding something.
But when the language that was used is like, if the defense has a piece of evidence that would show reasonable doubt. So by coupling that, the defense's ability to produce evidence with the notion of reasonable doubt, which doesn't require any affirmative showing by the defense, does that make this a little more problematic?
I don't believe so, Your Honor, for a couple of reasons. Number one, I don't recall that. Let me look at.
If there's a piece of evidence that would prove or would show that the deaf gets cut off and changes direction, there's a reasonable doubt as to the defendant's guilt. And then essentially they have subpoena power, they can bring in witnesses.
I don't believe it makes it more problematic in this situation, Your Honor, also because the defense in their closing argument told the jury that in order to be convinced beyond a reasonable doubt, they had to be certain as to the exclusion of all other possibilities. I think that defendant's commentary on the certainty, which in my belief is a misstatement of the burden of proof, alleviates any question that the state's use of the words reasonable doubt and saying subpoena power is not prejudicial. And I also still think it is not error. Even if the court considered it error, Your Honor, the evidence in this case was overwhelming. So I believe it's harmless beyond any reasonable doubt if it was found to be error.
Counsel, you mentioned in relation to the prosecutorial error, a case, and I didn't write it down, and I want to make sure. I'm looking at your brief and I'm not seeing that you cited it, and that's why I'm probing here. So maybe I just misheard the name, but I want to make sure I'm looking at.
I'm mispronouncing it, I'm sure, Your Honor, but it's on page 25 of my brief. It's State v. Duong 292.
Oh, okay, I got it. Thank you.
Scanlon. Yeah, that's it. Your Honors, I have 5 minutes left.
But yeah, to go back to the, I want to go back to the first issue and explain to me how the discovery agreement works. And I know you said it's different with different judges that in the district court, but what happened in this case, or can you tell me? Because I know sometimes it's pretty loose from my own recollection of mine, but that was a long time ago. And I don't know if it's been more formalized, because it probably should be, but what is it?
Standard practice from what I understand, Your Honor, and I think this was the situation when you were on the district court bench in Shawnee County as well, was the district attorney's office has a contract essentially saying you're requesting our file, it's open to you for inspection. We will, we, as a general policy, produce it as opposed to having you come in and inspect it unless it's contraband
So
or.
in this case, did it go anything beyond that?
I don't recall, I don't believe so, Your Honor. I know that some judges have a standard practice that they will enter a separate discovery
Right.
order apart from but I don't believe that was done in this case. I could be wrong, but I don't recall seeing that in the record. So the only discovery agreement was the contract between the state and defense.
That contract and then looking at the statute.
Correct.
Okay,
Correct.
thank you.
Okay, so it seems like what it turns on here is when the defense counsel goes in, pursuant to this contract that we don't have in the record, that everything was available, but we're really just talking about right there by the exercise, the information or recorded statement, recorded statements, which are in the possession, custody, or control of the prosecution, which it wasn't, the existence of which is known, or by exercise of due diligence may become known. So really, the issue here is the exercise of due diligence, right?
To a degree, Your Honor, I'd agree with that, yes.
Because you're going in and, and the argument here is you should have exercised due diligence.
And Your Honor, and I would agree in a perfect world if we had an army of police officers to review jail calls, and there are a lot of them.
Well,
Would have been
is
discovered much
the,
earlier.
Let me ask you this, though. I mean, you're conflating police officers and prosecutors. So, I mean, are you talking about one and the same?
Yes.
Because when you go into the prosecutor's office, do they have everything that the law enforcement officers have?
Not necessarily, Your Honor. Obviously, we don't have drugs, we don't have weapons, we don't have child pornography.
So does the statute cover? Is it the state's position that the statute covers what law enforcement has? Because I couldn't really find a case on that.
Other than Brady violations, Your
Right,
Honor, I
other
can't-
than Brady
I
violations.
can't either. I don't believe that the statute extends to everything law enforcement may have in their file. I know sometimes district court judges order certain things in a law enforcement file to be disclosed, like field notes or mathematical calculations on accident reconstruction.
But all that is speculation here.
Is, I don't,
Okay.
at
And
this point,
Brady is exculpatory, and you're, in this particular situation, we're talking about inculpatory. So I'm not really. So is it the state's position? What is the state's position on whether or not this statute covers what law enforcement has?
I don't believe the statute extends that far.
and is that because you view the language of the statute and specifically the exercise of due diligence may become known to modify only which are or have been in the possession, custody, or control of the prosecution?
With the exception of Brady material, yes, Your Honor. that
Well,
would be
yeah,
my view.
I don't want to get too conspiratorial here, but then what's to prevent law enforcement from just holding information until and what happened here? I don't understand why you can't impute for your lead detective what what is in possession of that detective that you're going to use at trial.
If it were exculpatory or potentially useful for impeachment, I agree it would impute. In this situation, it was inculpatory.
So law enforcement can, let's just say, I knew about this. The detective knew about this phone call, but I'm not going to disclose it to the prosecutor until a couple of days before trial. And then the situation happens here That's not contemplated by the discovery statute?
Your Honor, my response to that would be, I don't want to get too conspiratorial either. I don't believe that police knowingly, with extreme exceptions, look out to withhold information, particularly in a situation like this where the evidence helps the state's case. I do think this was an issue of having a detective having to triage his investigation. As we all know, we're up there, everyone's very busy. Should he, have maybe looked at it sooner, or would that have been more beneficial to all parties? Probably. Does it amount to a discovery violation? I don't believe so.
So I guess the issue here is the due diligence on the part of the prosecutor or on the part of the law enforcement officer? Because that would get rid of the conspiracy, because if the law enforcement officer had it, then the prosecutor upon due diligence would know that.
I mean, that is one way to read that statute, Your Honor, because again, my position is applies to the state as far as the state prosecutor's ability to permit inspection. Now, that being said, I believe that there was a question posed by either Justice Wall or Justice Stiegel, or maybe even Your Honor, I don't remember, about couldn't the defense have just asked to listen to these on their own initiative? I was a defense attorney for quite a while. I know that jail calls are notoriously bad for the defense because of things people say on jail calls. I don't believe there's anything to show the defense didn't have the ability to inspect on their own.
That's not, but
It
that's
does
not
that.
under the statute.
No, that was one of the.
That's a different.
Yeah.
How far does it go? I mean, what if it's medical records that are inculpatory? State responsible to get the medical records, or does the defense have the obligation to do that him or herself?
Don't know why the defense would go seeking inculpatory evidence other than maybe to try and head off a potential issue client is being accused of. I do think that if I knew something as the prosecution that would be potentially inculpatory, or even, well, the medical records, you never know until you see them, I would go get them myself. But that is just my practice as a prosecutor. I try and be as diligent as I possibly can, given that my have with my caseload, and also trying to abide by my professional obligations.
If we would get to harmlessness, this information was very inculpatory as to the distribution of the controlled substance. Did the state argue that did the state use this to argue anything related to the murder conviction?
I believe they argued for its admission that it was established that it went to motive. I don't recall the state making a huge issue of the jail call with regard to the murder in its case in chief or closing. I think more of that came from the two eyewitnesses, as well as the surveillance footage and the ballistics. And
But wasn't it
And
a
does that-
felony murder?
it was.
Well, was it based on the aggravated robbery or the distribution of controlled substance?
It was based on both.
Well, then, isn't it
The conviction was for second degree intentional, correct?
Correct. I believe so, Your Honor.
okay, so they
So
did,
when we get to second degree intentional, how, if it at all, does that evidence weigh in?
Well, Your Honor, as I recall, the allegations were the victim and the defendant were involved in a distribution organization. Victim would give drugs to defendant to sell. He would give money and presumably take a cut after he sold the narcotics. Sometime prior to this, he had been robbed of his stash and his money. Defendant shortly before his murder, not to me, victim shortly before his murder was saying, "I need my money." So I think the state's argument was circumstantially because the person on the other call was supposed to be the defendant's brother, but that never really got established. So the defendant's statement was, I recall correctly, I'm not getting my fair share. I'm doing all the work and I'm only getting a little bit of the money. I think that more went to the drug distribution than the murder. Again, I don't recall the state placing a huge emphasis on that being the motive. The motive seemed to be he owed him money, and after he was killed, they took a good portion of his stuff. Your Honors, I'm out of time unless the court has additional questions. Sure. Thank you, Your Honors.
You reserve 2 minutes? Or 3 minutes, I'm sorry, I can't.
Couple things I did want to clear up. Number one, he was convicted of felony murder. He was charged with felony murder and the alternative first degree premeditated. The district court instructed on both, including then the lesser included of second degree. The jury came back with a conviction for felony murder and second degree. Felony murder, then second degree, then merged at life sentence with a minimum of 620. So it was felony murder, and the statements as far as my client on the phone complaining about his cut of the drug deal was a big part of the state's case. To the murder, not just the distribution. They argued it was a confession that he was involved in distribution, but they also argued it corroborated their theory that this murder was because my client was unhappy with the cut he was getting. So it was a key piece of evidence for the state on the murder charge too.
But would it affect second degree? That's where I'm struggling. I mean, assuming that we have a valid, would we still have a valid second degree, even if we said it influenced the felony murder?
I don't think you would have that either, Your Honor. I think the state used it to show that this was a murder, not because it shows the motive behind the murder, that this was certainly an intentional murder, according to the state. Not only because mad with his drug cut, but also because it shows that he had talked about it, and certainly this was not something that was. I think it does support both charges, and it was a key point of the state's case. Second thing I did want to point out, I know there's some questions about the discovery order. I just want to quickly point the court to, and this is record 8, page 268. The defense counsel said there was a discovery order, and I put in for discovery. They don't go beyond that. And then also in volume 9, page 478, the defense counsel again says, I had asked for discovery as soon as I got appointed. So there was talk about this discovery order, but they don't go in anything beyond that. The other point I wanted to make was Detective Regan testified he listened to these calls long before trial, but he then kind of tapered off and did other things. No reason why he couldn't continue to do that. I understand everybody's busy, but that's not an excuse. If the state wants to use evidence against my client, they have to timely disclose it.
Guess I kind of want to bore in on that a little bit, going back and rereading your brief during. And the way you frame the error is that there is a discovery violation. And the discovery violation that's cited is 3212 and 3213. Either one of those statutes create the obligation that you're arguing for here. And I'm having real trouble finding a violation of discovery in here. I mean, I understand the fairness thing of somebody coming in and waiving evidence at the last minute. But in terms of a discovery violation, everybody seems to agree the detective didn't come across, wasn't hiding it, didn't come across it. You're saying they weren't diligent enough. Where's the obligation in any of these statutes to be that diligent?
Your Honor, I think when you look at discovery statute 223212, it talks about the existence of which evidence of which is known or by the exercise of due diligence would be known. And that's where the failing is here. They know, the state knows that jail calls, and the state said it to this court today. They're oftentimes great evidence against the defendant. They know about that. Detective Regan was looking at him from the get-go. Shortly after my client was arrested in May of 21, he started listening to the calls because he knew there could be something there. He chose not to continue to do that.
But your argument is not just due diligence, there's jail calls. Your argument is you have to know the substance of the evidence. In other words, everyone knew there were jail calls. It seems to me, there was absolutely nothing preventing the defendant from inspecting, copying, or photographing all the jail calls.
There probably wasn't, but that's not the point of discovery.
Well, but that gets to this disjunction between what you continue to argue is the point of discovery, i.e. the state has an obligation to disclose certain things, not the language of the statute.
The language of the statute says the state shall permit the defendant to inspect, copy, or photograph, et cetera, et cetera.
And it seems like that was met here. That's the defendant was permitted to do that.
Not in a timely fashion because they did not exercise due diligence.
But
in
what you're
finding-
complaining about is we didn't know the content of the call. That's different from we didn't know the call. We didn't know about calls at all. We just didn't know we could look at calls. Right?
The defense didn't know the state was going to use this call against my client at trial.
And is there anything in the discovery statute that conditions actions of the state on what they're going to quote unquote use?
I believe so, because the
Where
statute
is that?
says they shall permit the defense to inspect, copy, or photograph all of these things.
But it doesn't talk about what's going to be used in trial.
No, but if they want to use it in trial, they have to allow that inspection. For those reasons, we would ask that this court reverse and remand this matter for a new trial.
Thank you to both counsel for your arguments today. The court will take this matter under advisement